On the question of foreign law, you yesterday said this: unless the statute requires or directs you to look at foreign law, and some statutes do, by the way, you go on and say, quote, the answer is no. Foreign law cannot be used as a holding or a precedent or to bind or influence the outcome of a legal decision interpreting the Constitution or American law. That's a pretty good statement, I think. But this is what you said before in your speech to the American Civil Liberties Union, actually in April, just 2 or 3 months ago, in Puerto Rico. You said this, quote, international law and foreign law will be very important in the discussion of how we think about unsettled issues in our own legal system. It is my hope that judges everywhere will continue to do this, because within the American legal system we're commanded to interpret our law in the best way we can, and that means looking to what anyone else has said to see if it has persuasive value. So that's troubling. Now, you also said yesterday that you agreed with Justice Scalia and Justice Thomas on the point that one has to be very cautious even in using foreign law with respect to things American law permits you to do. I don't think that's exactly correct or a fair summary of the import of your speech. This is what you said before the ACLU group a month or two ago. Quote, and that misunderstanding about using foreign law is unfortunately endorsed by some of our Supreme Court justices, both unfortunately endorsed. Both Justice Scalia and Justice Thomas have written extensively criticizing the use of foreign and international law in Supreme Court decisions. They have somewhat a valid point, and you point that out. But then you go on to say, but I think I share more the ideas of Justice Ginsburg and her thinking in believing that unless American courts are more open to discussing the ideas raised in foreign cases and by international cases, that we're going to lose influence in the world, close quote. So everybody knows there's been a fairly robust, roaring debate over this question. There are basically two sides, one led by Justice Ginsburg and one led by Justice Scalia and Thomas. Don't you think a fair reading of this statement is that you came down on the side of Justice Ginsburg?
No, sir, because these conversations were in the context, and discussions were in the context of my pointing out, just as she had, that foreign law can't be a holding. It can't be precedent. It can't be used in that way. She was talking about the way I was to, and what I said in my speech at the beginning and the end, ideas. What are you thinking about? Judges use law review articles. They use statements by other courts. The New York Court of Appeals, in a recent case, looked to foreign law to address an issue that it was considering, not in terms of a holding for the court, but a way of thinking about it that it would consider. My point is that I wasn't advocating that it should ever serve as precedent or ever serve as a holding. I was talking about the dialogue of ideas.
Well, I just think that you laid out the two positions and you came down on one side. And I think that's a fair summary of that speech, which others can read and make up their own mind. You were asked about the PERLDEF, the Legal Defense Fund, of which you were a member and a member of the board for 12 years. And in response to Senator Graham's question, you say you'd never seen any briefs and that the main focus of your work at the organization was fundraising. Is that accurate?
When I was responding to the senator, I was talking about the board in general. I belonged to many committees, and so I did other things besides fundraising, but I was beginning to explain what the structure of the board was and what the primary responsibility of board members is. But clearly, board members serve other functions
you did,
in an organization.
Serve on the litigation committee, and board opposed to, I would think, and legally are required to superintend the activities of the organization that they're a member of. And then you have committees of the board who do various things. I'm looking at a June of '87 document, report minutes of the board. The litigation committee, Sonia Sotomayor, reported that the committee, in addition to reviewing and recommending a litigation program, had identified 3 initiatives. In October of '87, I'm just looking at some of the documents we were given. Litigation report. Quote, Chairman Sotomayor summarized the activities of the committee over the last several months, which included the review of the litigation efforts of the past and present and initial exploration of potential areas of emphasis. Member Sotomayor advised that a preliminary report would be provided at January meeting. And then at the January meeting, there's about a 50-page document summarizing 30 or more cases that the board had undertaken. A number of them are pretty significant and very consistent with the kind of case that we had in the firefighters case, where the board had filed litigation to really basically insist that you have perfect harmony between the applicants for a job and those who are selected for promotions. Isn't that true that you were more active than you may have suggested to Senator Graham yesterday?
No, because as I said, I started to describe the role of the board generally, and we were not addressing the question of what I did or how I participated. That memo has to be examined in context. The memo was a moment in our 12-year history where the board was planning a retreat to think about what directions, if any, we should consider moving into or not. We were not reviewing the individual cases to see if the individual cases, what positions were taken, the type of strategies that were chosen.
Didn't you know the cases that you, the position the organization was taking? Well, my time was running out.
I was wondering if you'd like to finish answering the question.
I'll let you answer, but I'm just
the end of my answer was the fund had been involved in a series of areas: employment, public health, education, and others. And so the broader question for the fund was, should we be considering some other areas of interest to the community? We held a retreat in which speakers from a variety of different civil rights organizations, academics, number of people came and just talked to us. I don't actually remember there being a firm decision that followed that, but it was a part of a conversation, the sort of retreats that even my court has engaged in. What are we doing? What are we thinking about? But it wasn't a review of each individual case to judge its merits.
Judge,